Welcome to the first session of our 2020 webinar series, co-sponsored by the Ecological Law and Governance Association and a number of institutions, which are at the top of the flyer. The host of this webinar is the leadership for the Ecological Law and Governance Research Initiative, and I'm very pleased that Carla Sbert is going to join me for this. Please take note of the full webinar series at the EL&G website, which is on the flyer, and I believe you've all received that. We hope you'll be participating in as many webinars as you can make. Another thing I'll mention is that we'll try as well to include some background readings for people to take a look at before each webinar. Plus, both Carla and I will make our PowerPoints available to everybody because the concepts we're going to be going through today can be quite complex. We will have a good amount of time for discussion, but you'll also have those PowerPoints, and this webinar will be recorded if you want to go back and listen to it later. So I'm going to get started with the way this will proceed today. I'll give a brief introduction to this idea of ecological law case studies. Carla will then present her analytical tool called the lens of ecological law. And then I'll follow with another example of a tool that can be used in these studies, plus some very brief examples of the kinds of things we might apply this methodology to. So I'm going to share my screen. Hopefully you are now all seeing my PowerPoint environmental law case studies. Can somebody nod and say that you see that if you do?
I see it.
Very good. Thank you very much. Another comment here. If it's best if you can put yourselves on mute while Carla and I are speaking, and then when we get into the discussion, you can unmute yourself to ask questions. You can also, during the webinar, you can put in questions or comments that come to you as we're going along in the chat function, and we'll be following that. And if sometimes we may just ask the question out of the chat function instead of recognizing you. But we are setting this up today to have a good amount of time for discussion and brainstorming. So, environmental law case studies, an introduction and illustration. Let's start just talking about what ecological law case studies are. This is an idea that we had to try to give some concreteness to this somewhat theoretical idea of ecological law. So the idea is to base them on real world situations, which could be a particular project, a development project, a policy, some sectoral feature like urban infrastructure, transportation infrastructure, and so on. And the basic idea is to take one of these situations and then deconstruct it by identifying all the legal and policy features of that situation that apply both directly and indirectly and at all governance levels. So a kind of brainstorm and really trying to think outside of the box as much as possible about what is the legal and policy infrastructure that's behind this particular situation in the real world. And then after analyzing what's going on there, the second main part of these studies would be to reconstruct this situation under a regime of ecological law. So that would involve describing all of the legal and policy features that would apply if we had a fully built, or maybe a transitional system of ecological law, and again at all levels from the local to the global. So this schematic just shows you basically the idea here. So first deconstruct, and what we want to tease out there is really every part of every kind of law that would apply. So not just environmental law, but also what are the property law regimes, the labor law regimes, trade regimes, and so on. And again, at the local to the global level. Then conduct some kind of analysis to see what of that situation seems to be inconsistent and what might be consistent with the ideas of ecological law. And then to reconstruct the situation again under a regime of ecological law. And because certain aspects of ecological law can seem so far in the future and so theoretical, it could be very useful for many of these situations to describe a transitional situation as well as to describe an end goal or final kind of reconstruction. Well, why do these ecological law case studies? First, again, is to try and show concretely how ecological law transforms all areas of law, not just environmental law. I'm involved with several others on a book project, which we're calling From Environmental to Ecological Law. And ecological law is often cast as a counterpoint to environmental law. But if you have a system of law which is ultimately ecocentric and which is governed primarily by ecological primacy in decision making, then it becomes a logical follow-up that it has to apply to all areas of the law and not just environmental law. So part of what we're doing here is to try to make that more concrete and clear. Another thing is to make clear the deep inadequacy of many aspects of the status quo and the nature and difficulty of several of the obstacles to overcome. Some aspects of ecological law may be more readily implemented compared to the status quo, but certainly some of the more deep-seated concerns that ecological law is trying to address will take longer time. So putting ecological law into these real-world contexts should help to illustrate the depth of those challenges. Another is to highlight transitional forms in the direction of ecological law. So rather than just throwing up our hands when this transition seems too difficult or too far into the future, we can try to identify situations that would be transitional along the way towards a fully built system of ecological law. And finally, these case studies should overall illustrate a clear vision of ecological law, not just in the books, not just in our heads, not just in theory, but on the ground as best as we can. Who does these studies, for what audience, and how? Well, the key answer here is flexibility. What, at this point, those of us who've been thinking about this have in mind is this could be individual researchers, or in my view, ideally, teams of researchers. The audience could be the academic community, reform-minded and activists, policymakers when there seems to be an opening, the general public, and so on. I really want to be expansive there and not limiting. Again, in terms of the methodology, as well as the audience and so on, flexibility is key. The idea here is to let individual researchers or teams of researchers to come up with the situations that they want to address and to figure out a methodology that makes sense. And I'll have some, well, Carla and I will both have some illustrations as we go through the webinar today. So I just want to go over a few of the big picture features of what we want to draw from as we do these case studies. So it seemed to me really important just to be aware of all of the relevant features of legal systems that we'd have to be looking to when we did these case studies. So first of all, recognizing that legal systems are always in the context of other systems with which they interact. The local to global ecosystems, social, political, cultural, and economic systems. And underlying at least all of those human created systems are always a set of worldviews and ethics that have to be kept into account. And ecological law case studies, I think if they're done well, are going to have to address some of those questions of worldview, as well as more superficial aspects of the situation that are being addressed. It's also important to be aware of the many different forms that law and policy can take. So the things that we are all, I think, familiar with: constitutions, statutes, common law and civil law are different. So common law traditions as well as those of civil law, regulations, decrees, policy, treaties, the kinds of things that we typically associate with law, but also less typical aspects of law or forms of law, such as indigenous legal traditions, customary law, and so on. These case studies really are a good venue in which to explore and apply legal pluralism, the many ways, both formal and formal, in which societies come up with norms that guide behavior relatively consistently or predictably. And then again, we have to keep in mind all of the actors, agents, institutions, and power structures that are related to law. We have legislatures, judges, the people to whom law applies, the enforcers, all kinds of institutions at both from the local to the global level that are involved in maintaining a legal and policy infrastructure. I mention these just to make sure that we have an open mind, or to encourage you to have an open mind about what's involved in doing these case studies. And then there's a multitude of arenas in which these law and policy systems exist. So you have rights-based regimes, a whole host of rights and human rights that are recognized at various levels of law and policy, plus those of juridical persons. Most familiarly corporations, but now more and more non-human nature. And the rights of nature movement and the develops in that arena are very relevant to this, these studies. You have legal regimes that are involved that are primarily economic. So they're dealing with the economy, financial and monetary systems, contracts, commerce, trade, and so on. And then a whole set of regimes that are dealing with various forms of property, including notions of common property. And then various sectors that may be particularly interesting to include here: energy, food, water, transportation, natural resources, land use, and so on. And then here, I really don't want to spend too much time with this, but I'm just recalling here some of the key features of ecological law that have been identified. This is a list that I've come up with my research, but other researchers have identified similar features. So the idea of ecocentricity, that humans are part of Earth's life systems and not apart from them. The idea of eco-primacy, which Carla will be talking about more, that we in a system of ecological law, we're giving primacy to ecological boundaries over socioeconomic spheres and ideas such as infinite economic growth. Again, part of the purpose of these studies is to show that ecological law is fully integrated in all aspects of rule and policy. It's not just a boutique area like environmental law has tended to be. A new feature that I'm including in my list now that really comes from Carla Sbert's work is that the use of biocapacity and extracted materials is based on real need, not on utilitarian desires or market price. We think about resources, metal resources, or oil and gas. Think about how important the role of price is, rather than a true shared consideration of what's really needed there. And that, the stakes, I think, are becoming higher and higher with something like that. Questions about the application at various levels of governments, issues of justice and fairness are important. Ecological law has implications in terms of what kinds of research and monitoring we would need to do. It's really calls for being cautious about various things, including crossing planetary boundaries. And ultimately, as a systems-based approach, it calls for adaptive approaches. Here's a quick summary that I've developed on the difference between ecological law and contemporary law. I used to head that environmental law, but again, I want to emphasize that ecological law really responds to deficiencies in all areas of the law. Without going through this in detail, we can see that there are key differences in terms of the view of the human-nature relationship, the enforceability of environmental and ecological limits, key considerations in terms of the use of material and energy, different views with respect to the scale on which law and policy operate, different notions of fairness, and then again, different notions of what's important to study and of being adaptive. So here I just want to do a quick review of various analytical tools that we've identified to date as being applicable. So the first is the lens of ecological law, and after this slide, I'll be turning the presentation over to Carla to tell you more about that. Another tool that I've been developing is called lock-in lockout assessments, and I'll explain that a little more after Carla speaks. Various methods are emerging using ecological limits like planetary boundaries, ecological footprint, and so on, as well as various methodologies that are growing out of ecological economics, degrowth economics, donut economics, and so on. These case studies might involve community and stakeholder consultations or interviews with various knowledge holders about the situation. And I think that they lend themselves very well to interdisciplinary approaches. So we're not just intending these to include law and policy folks, but a broad range of disciplines and knowledge holders. The last point is key. The choice of analytical tools, and this is not a complete list, is really, again, up to the study team or researchers to decide upon using brainstorming sessions and so on. And I hope we'll have a little opportunity at the end of the presentations to do a little of that today. So I'm going to now turn the presentation, the webinar, over to Carla, who's going to tell you about the lens of ecological law.
Thank you so much. Can everybody hear me? Okay, good. Hello. So to share my screen, okay, let me just make sure I get this right. And the problem I was having is, share, okay.
Press that and then you'll be able to choose. There you go.
Oh, there I can choose. Wow. Technology is quite impressive. Okay, that's how I. Perfect.
And then
thank you.
You can click the little screen thing down there, and then you'll get down at the bottom to the left, the third one in,
okay.
right next to slideshow, and that will make us only see the individual slide instead of all of them. Go to the left of slideshow down there.
Wait,
a little,
there?
A little left.
That?
No, the next little thing to the left of slideshow.
Oh, God. Oh, right now you're seeing all of my slides or?
Yeah, yes. So
I see.
Go down to where it says slideshow and to the left, and the little thing that looks like a screen, kind of.
Mm-hmm.
Point to the left. Move your arrow to the left. Down.
Wow.
To the left.
To the left.
Right there. A little to the left.
I don't
there.
see.
Press that. Press that. Right there. Click. No.
I'm pressing and it's making a noise. It's strange. What?
Right there.
I'm seeing only my first slide. You're seeing everything?
You don't have to do this. Yes, but yes. So yeah. Like, Carla, you can just continue like that. We can say it. Okay.
Oh, this is terrible. No, that's.
The other thing is
you're seeing everything.
Yes, if you see that, do you see something on the top that says slideshow?
I am so sorry. This is terrible. I see something that says stop share. New share, stop video. No.
No.
It'll be on you. This is Katie. It'll be on your computer screen, so not part of the Zoom. And there's 3 little buttons. See your rows of slides, 1, 2, 3, 4, 5, 6? To the left there. There's 3 little buttons at the bottom. And right now you have the leftmost button pressed. And you want that 3rd button. See, yep, you're almost there. A little bit more to the left. See underneath your 1, 2, 3, 4, 5, 6? That row of slides.
What I'm seeing in my screen is, okay, I'm going to end the show. See if,
oh, okay.
Did that work?
No.
What do you see now?
And see, you have an Apple, don't you? Because you can also press F5 with some systems, and that'll do an automatic slideshow. You can also hit the play button on your screen.
Okay.
That might work as well. And if for some reason it's timed, just make sure to go backwards and forwards with your up and down. So that little circle play with the green
I did that just now.
Oh.
What do you see?
And it's still the same layout. So yeah, I think you just need to go to the bottom of your rows of slides. You have 1, 2, 3, 4, 5, 6, and there's 3 little buttons underneath them. One is 4 little squares.
Mm-hmm.
And to the right of that one.
Okay.
That one, click that. To the right of the 4 little squares. Should be it.
That's what I just did. It didn't.
Yeah.
You're still seeing everything?
It doesn't show that you pressed it in.
Stop sharing, Carla, and I can do it. I have yours open here. And
that's a good idea. Yeah, so you can talk, and then Geoff can do your slides. Sorry about this. It's not the easiest system, so I wouldn't worry about it at all.
Yeah. No, it may be my computer's too, my system is kind of old, and it maybe it's not recognizing all the features, because I was doing what you said.
Yeah, that's possible too.
It just wasn't.
No, yeah, I wouldn't give it a second thought. This stuff glitches all the time. So, okay, cool. I think we're all set now. Okay,
great. Well, thank you. I'll just go like that or something for Geoff to move along.
Right, perfect.
Sorry for the delay, the technical issues. Anyway, I first of all want to very, very warmly thank both Geoff and Catherine for inviting me, for having me in this very exciting initiative. I'm really honored and thrilled that my lens is potentially going to be part of these really exciting case studies. So thank you. And okay, next slide. I'll get straight into the weeds of this lens of ecological law. So what is it? It's an analytical tool for assessing existing laws and sort of asking how far are these laws from ecological law, and trying to identify obstacles and opportunities for a transition from ecological law to, from existing law or current laws, or contemporary laws, as Geoff just called them, to ecological law. And it's a tool that I developed based on existing ecological, or the fundamental, or what I've found to be the fundamental ecological law scholarship. It's not, I'm not really proposing any ideas in this lens and these principles that are not already reflected in the literature. Next, please. Next slides, please. So the lens of ecological law, yes. No, I think you skipped one, right. So it consists of 3 interconnected principles, yeah, no. And the 3 principles are ecocentrism, ecological primacy, and ecological justice. And essentially when I was trying to figure out the principles, I decided that what would be useful is that the principles have to be normative rather than descriptive, and that the main aspect that they have to focus on is reflecting one or several values that are critical to ecological law as an alternative to environmental law or to contemporary law, if we want to say it more broadly. And so that a principle of ecological law states a core one or two or more core values that guide behavior toward ecological loss objectives that, as I understand them as well, based on my review of scholarship, the objectives are to constrain the economy within ecological limits, to restore and preserve ecological integrity, and to enable an ecologically just society or a mutually enhancing human-earth relationship. And there's obviously a bit of a progression in those objectives. So these principles are linked and reinforcing, and they also try to elucidate different functions of the law, and this is an important aspect for them to be used as a tool. So I'll point to these functions as I go through each of the principles now. So the first one is ecocentrism, and it calls for recognizing and respecting the value of all beings and the interconnectedness among them, equitably promoting the interests of human and non-human members of the Earth community. So the function of this principle is the law's ability to support and promote a worldview in which humans are part of nature and no more important than other life. What it aims to do is prevent decisions that are not focused on ecological consequences, and also that have a bias towards short-term interests of humans, and instead of broader, longer-term interests of the Earth community. And so the focus of this principle is relational in a conceptual way. So it centers on what the underlying vision or worldview, not really worldview, the underlying vision of the relationship between humans and the Earth that the law has, what the vision that underlies the law. And so that's ecocentrism. So the second principle, next please, Geoff, is ecological primacy. And so this principle calls for ensuring that social and economic behavior and systems are ecologically bound, respecting planetary boundaries. The function here of the law that this principle focuses on is providing clarity about priorities, in order to ensure that any human activities that are pursued are not going to irreversibly impair ecological integrity, or are not going to cross planetary boundaries. And also an emphasis on precaution with respect to ecological limits and these boundaries. And this principle has a material focus, and I want to highlight those two aspects of that. The explicit reference to planetary boundaries means or is meant to underscore the need to consider ecological limits from local ecosystems to the planetary level. And it also implies a need for legal systems to incorporate the growing understanding of complex socio-ecological systems. So there's a lot packed, I guess, is part of what I'm saying here in each one of the principles. The other aspect that I wanted to highlight is that it's implicit in this concept of ecological primacy that ecological integrity is the reference point for ecological law to constrain economic activities. And so many of you may be aware of Klaus Bosselmann's argument that maintaining ecological integrity is the overarching goal of ecological law. And so others have questioned whether the concept of ecological law, especially as expressed in terms of pristine nature, is really the most appropriate concept. So I think because this discussion is still ongoing, I have settled with keeping ecological integrity as the reference point for ecological primacy, but with really emphasis on the fact that ecological integrity has to be understood as inclusive of humans. And again, some people may question whether that is possible but that's I'm getting too much into details. Anyway, so all I'm going to say about the ecological primacy principle, then the last principle of the lens of ecological law, Geoff, please, is ecological justice. And this principle calls for ensuring equitable access to the Earth's sustaining capacity for present and future generations of humans and other beings, and for avoiding an inequitable allocation of environmental harms. So the function here is to serve as ethical grounding for decisions about how we distribute use of the planet's capacity to sustain life, and also a fair distribution and restraint on wealth. So limiting excess wealth. The focus of this principle is relational, but in a practical and material way, so that in contrast to the principle of ecocentrism, it aims to translate respect for all beings into actual access to the Earth's sustaining capacity. So that's all of the principles that comprise the lens of ecological law. There are others that are possible, and I just focused on a core. So that's one thing to think about in using the lens. More principles may be relevant for a specific type of analysis. So how to use the lens of ecological law, and this again is based on my short experience with this tool that I came up with. So it's very straightforward, actually. Or at least the steps are straightforward. The analysis can be at times mind-boggling, but the actual steps are pretty straightforward. The first is and I must say that it's conceived for analyzing norms, but it can adapt it. It can be adapted, I think, to other things like projects or policies or I don't know what else. So the first step is to identify the norms, and Geoff presented a pretty comprehensive list of what can be included really in this first step. So I'm not going to get too much into this, just to say that the norms really depend on the nature of the case. And so, for example, in my mining case studies, I focused on norms governing access to minerals and governing decisions about what, why, where, how to mine, and who decides. So that was sort of like, okay, well, that was the extra lens that I used to decide what norms were relevant for my purposes. So the second step is to, and this second step was in actually trying to do the analysis. I found that the principles themselves are very general, so it's useful to bring them down one more level and ask, like tease them out with specific questions. So just to give you a few examples, under ecocentrism, one specific question that might be asked is whether the norms are recognizing the rights of non-human beings, or perhaps are constraining the rights of humans within ecological limits, or binding the rights of humans. An example for ecological primacy, a question could be whether the law constrains economic activities at the different ecosystem, watershed, or planetary level within ecological, at the relevant scale, right? So, and for ecological justice, an example would be whether access to, say, habitat is distributed fairly within generations of humans and other beings, and also whether human access is based on needs, as also Geoff already noted, has been, I think, an important conclusion of these analyses, that focusing on needs is useful. And it's particularly useful in ecological justice, but it also somehow comes up in the context of ecological primacy, because of the driver for many economic decisions is not need, but as Geoff mentioned, markets or price or wants. So then, after setting out these more detailed questions, simply the next step is to go through all the selected norms and analyze them based on these principles. And then a last step is to identify obstacles and synergies that stand out from the analysis. So next, please. My research so far has focused on mostly on mining, except for one first case study that I did when I was first thinking about the lens, where I used the lens to compare the Ontario Wildlife Act and the Nunavut Wildlife Act, because the Nunavut Wildlife Act incorporates explicitly into the act principles of Inuit traditional knowledge. So I thought that because of possible synergies between Indigenous principles and ecological law, it could be an interesting analysis, and it was, but I didn't take that comparison very far. So the rest of my experience using the lens of ecological law, and really that's what I've tried to focus this presentation on, like what is it like to use it, more than really the substance of the conclusions or the insights of the analyses. So the rest were all case studies based on mining, and very different case studies, or very different sets of norms, I suppose. And I chose them, however, all based on an expectation that they would lead to interesting results, either because there were elements in these norms that at first sight appeared aligned with ecological law. So the rights of nature in Bolivian law, or the metal mining ban in El Salvador, which is the first law ever, or country ever to set a legal ban like that, or whether there were elements that aligned with the values of ecological law. So the values that ecological law aims to protect, rather. So for example, in the case of the Ontario, the proposed mining in Ontario Ring of Fire, this is a region that is that has very, very little human impact, and is, in terms of ecological integrity, has been scientifically identified as having very high ecological integrity. So that was my rationale for choosing these case studies. And and just to say, when I was, like, after I did all these case studies, I did a short assessment of my experience with the lens, and pointed to some things that work better and others that don't, and I included that in my book that I will put in a little plug for at the end. Anyway, so if you're interested in more of that, that's there. Next, please. So I'm going to just get into a little bit more detail of one of these case studies to further illustrate what's involved or what was involved for me in using the lens. So in the case of the Bolivian lithium project, actually I started out by being interested in the fact that Bolivia has certain laws that recognize the rights of Mother Earth, and then I looked at whether they had an important or an interesting mining project. And so the norms, so they do. They have there's a major lithium industrialization project in a very remote and relatively untouched area, well, not anymore, of Bolivia. And so I selected several laws or several, well, the Constitution, two laws that specifically discuss rights of nature, and then two laws that were really prior to the introduction of the framework, sorry, of the law of the rights of Mother Earth. And so some of these laws are very, very elaborate, and they're long and very detailed. So I still had to select certain provisions, of course, from the laws. So there's several layers of, I guess, of teasing out what is the most relevant part of the law for analysis. And I found that there can be a certain circularity in this. So there's a little bit of a risk there, where you're analyzing the things that are most promising or most relevant, but perhaps then you're reinforcing your conclusions in some way. I don't know if that makes sense. So anyway, so the next slide, please. So Geoff, next. Thank you. So then I once I had narrowed down the norms that I wanted to look at, I did the lens of ecological law analysis, and I'm just going to point to just a few of the things that I found. So under ecocentrism, it was very obvious that both the rights of Mother Earth law and the framework law recognize rights of non-human beings, and they do it in a lot of detail. And so these really were examples of ecological law and of ecocentrism. However, other norms in that set that didn't even mention the rights of Mother Earth, or even included certain principles or norms that really were not compatible with ecocentrism. Under ecological primacy, specifically the framework law, which I must say tries to reconcile what the law calls, or what Bolivia has called, integral development, tries to reconcile that with a later stage of vivir bien, so a society that is really almost like an ecologically just society as we would see it. So the framework law is focused on trying to do this this reconciliation, and but it also provides an example of ecological law, in that it subjects economic activities to, including mineral extraction, to a principle or a standard of having to be in harmony and equilibrium with Mother Earth. And so if you read like all the definitions of what that means, it really amounts to a standard of respecting ecological integrity and requiring that any economic activities do not compromise it. So it's pretty impressive in the law itself. Next slide, please. And then in terms of ecological justice, the concept of BB2BN, I can't really get a lot into the details of all this. I hesitated using this example because it's very complex, but at the same time, one of the readings that was suggested in the overview of the webinar focuses on my other two case studies. So I figured, okay, well, I'll talk about this other richer one. Anyway, just as that little sideline to explain that I will have to be very general about explaining this part, which is very rich. But this concept of BB2BN, which especially the framework law puts forth, is very consistent with ecological justice and with ecological law, and in particular because of this focus on fair distribution and constraint of wealth, and also the respect of the rights of Mother Earth is linked in these laws to this concept. So another thing to say from the perspective of ecological justice about these norms is that the framework overall is very focused on intra-generational equity and really focused on eliminating poverty in Bolivia for obvious reasons, and eliminating inequalities within Bolivia. But there are several provisions in these norms that also strongly support both intergenerational and interspecies equity, which are the other two elements of ecological justice in Bosselman's terms. So and even this concept of integral development, which is kind of transitional to BB2BN, is also framed as having to satisfy human needs in harmony and equilibrium with Mother Earth. So it all fits very well with ecological law. And if we only look at the framework law and the rights of Mother Earth law, when we look at the Constitution and the mining law and even the environmental law that just ignores all these other positive elements, we see resources or the other beings and the components of Mother Earth treated rather as natural resources and as property. And even the mining law rejecting the free prime and informed consent of indigenous peoples as a requirement, and very specifically saying that what's required is free, prior, and informed consultation. So I mean, at least they don't lie about it. They're more transparent. So that's all in terms of the analysis of the norms that I selected in this case study. And then next slide, please. And then I looked at the yes, thank you. Next slide. Then I looked at the actual, this mining project. It's a very large project with a lot of hopes because the hope is that it's not just going to be an extractive project, but it's also going to be one in which Bolivia is going to develop the actual batteries, not just extract the lithium, but actually industrialize the minerals, and so they frame it as this transition towards BB2BN. Only in political discourses, because actually when you look at all the documents that I had access to just online and in studies. I didn't go down there to actually do any interviews or any research there. But from what I had, I was able to access the reports from the company the state company that leads these mining projects. There is no mention of the rights of Mother Earth or the framework law. There's no evidence that that these have been considered in defining and implementing and reviewing the project. As I said, this area where the lithium has been found, it's called the Salar de Uyuni, and it's a very unique ecosystem, very remote and very poorly understood in terms of ecological limits, and so precaution would require that a lot more be known about what the limits are and how to ensure that a major mining operation would not cross any of those ecological limits. And there's no evidence, or I found no evidence of that. And then another thing to say is that although lithium is a mineral that's necessary for renewable energy production, and so in some ways it's part of the solution. We really have to ask harder questions about that. How much of the demand of lithium is really needed for a solution to climate change, or how much is it just going to answer to greater demand of privately owned vehicles and endless consumption of other electronics and so on. So that's a very brief summary of the case study, but I hope it gives you an idea, just like a sense of how I have at least experienced applying the lens. And my last slide, I'm not going to really go through it, but it's just to illustrate that after one next step is after doing the case studies themselves, there's material for what Geoff has called reconstruction, right? For imagining under ecological law, and I did a little bit of that in my analysis, imagining under ecological law what an approach to mining would look like. And so that is all for me, and I thank you so much. Last slide, please. Thank you so much for your attention, and oh yes, and get my book, please, or recommend it to your librarian, because I shouldn't be saying this, but it's a little on the pricey side. But everything I said is essentially in there, and I would be more than happy to answer, in addition to here, like any other questions by email or hook up to chat further. Thank you so much.
Thank you so much, Carla. That was a terrific presentation. I think I really want to applaud your work on this. You've made and I continue to make such a great contribution to ecological law. I know that book is going to be on my bookshelf, and it's so great to be working with you on these case studies and other things. I just want to do a quick call out here for our sign-up sheet, which I haven't told you about. It looks, where is that? No. Well, I'm going to put up a link to a sign-up sheet, and I hope that you'll here we go. Okay. Okay, I am going to just quickly show you. This is the sign up sheet, and I'm going to copy this link. I want you to put your name there. And it will be in the chat function. So please do go there. Okay, that's set for you all to edit it, which means you can put your name and your contact information. Please do that so we have a sense of who's participated here today. So I'm now going to continue with my presentation and go through this fairly, whoops. I'm going to go through this fairly quickly. No. Are you seeing analytical tools? Can someone just give me a signal there?
Yes, analytical tools examples.
Okay, great. Thank you. Okay, so again, Carla's, I hope you saw just how well her lens can apply to this work. I've developed what I'm calling lock-in and lock-out assessment, which is really an analysis of how hard some of the obstacles to a regime of ecological law and policy and governance are to overcome, and how resistant the current system is to putting in place some of the features of ecological law that we would want to have in them. So that some things are locked in, we want to get rid of. Some things are locked out, that we want to have. And you'll see with the overall idea here is that we want to move from our current regime, which I describe also as having growth insistence as one of its most fundamental objectives, to one in which mutually enhancing human-earth relationships would be the primary goal. And there is this zone of transition, and that's why I think it's very useful when we do these case studies to consider not only the final endpoint, but transitional regimes that we can get to on the way. So one aspect of this assessment tool is to identify points of intervention in legal systems. So ways in which you can affect larger system-wide change. And at the deepest part of a system are the paradigms, and even in transcending paradigms, where you have a pluralistic view of the various paradigms that apply. And then deep-seated goals, things like economic growth, or, as I just said, mutual human-earth enhancement, and all the way up to more superficial things. And the superficial things are the kinds of things that our laws often tend to deal with, things like our air quality standards, tax rates, the number of Supreme Court justices in the United States. Those would be sort of the most superficial level of the kinds of things you can change in a system. So it just goes to show how difficult some of this work could be. Again, the deep-seated ones are more fundamental, harder to change. The more superficial, in theory, easier to change. And then the second aspect is just to look at the degree of lockout of various things that we want to either come or that we want to promote. And here I just have a list of some of the things that we might want to overcome. So growth insistence, the global objective to keep pushing economic growth, even if it's called sustainable economic growth. Well, that's very, very deeply locked in and might take a long time to overcome. I'm not going to go through all of these, but just to give you a sense of what I'm talking about here. These are systems features that either exhibit good or bad resilience, depending on your perspective. Some kind of things we want to promote. You know, the idea of local governance, or the focus on place-based governance is involved in things like subsidiary and supranationality to deal with issues that require interventions at a higher level, like climate change. There's a lot there. Again, it's really, I'm just doing this mostly to familiarize with this tool, and I'm happy to talk to you, as Carla said she would, about any of these ideas further in further sessions or individually. I'll give my contact information as well. I'm not going to go through these charts. I just want to give you some ideas that I had of kinds of things that we could apply these case studies to. So one is a place just down the road from me here in Montreal called Quartier Distrant. I put the trademark symbol in there. It's what's used on their website, and it really just kind of puts the accent of what this place is all about. So it's called the Distrant because it's at the intersection of Autoroute 10 and Autoroute 30, and it's described in a Wikipedia article that I saw as Canada's first lifestyle center. So just take a moment to let that sink in, and here's some images of what that lifestyle center looks at. So it's described in Wikipedia as a commercial lifestyle center located in Brossard, Quebec, designed to emulate an urban or downtown shopping experience. I wish I had some nice music to play for you here. With boutiques and to meet the needs of suburban dwellers living on the South Shore of Montreal. Okay. I hope you can see why I thought this might be an interesting thing to subject to one of these case studies. It raises questions of the ultimate worldview, or the view of the human-earth relationship, or the vision of the kind of future we want to have. That could be deconstructed in all kinds of ways, to sort out the various ways that's reflected in a whole set of laws and policies. It accentuates how we promote either true need or utilitarian desires. I would say this is really a model of allowing people to fulfill their utilitarian desires in the most efficient way in terms of modern economics, how that treats it. It raises questions at the global level, because a lot of what's going to be bought and sold in these global brands that are set up in that shopping world are in globalized trade, as well as laws and policies all the way down to the local or regional level. Big questions in this kind of a study of an example would be on land use. So this is land that was very good farmland within the St. Lawrence Valley. It's the breadbasket of Quebec. And that farmland right now has a higher value for suburban development than it does for farming. It's situated at the intersection of two autoroutes, meaning that part of the lifestyle that's being promoted here is one with a lot of car dependence. You can't really get there very easily without a car. And there's a lot of parking if you look at the maps of the community. The lifestyle, what is this lifestyle all about? Shopping, consumerism, global brands, a particular kind of labor. I guess, you know, might be nice for baristas and retail salespeople. There's a whole entertainment agenda, which also reflects the kind of worldview and values that are underlying it. And it promotes a certain notion of community, which I would say is pretty far removed to a mutually enhancing human-earth relationship. Now, in terms of planetary boundaries, those might not be obvious, but the car dependence and other aspects of this would be certainly have implications for climate change. Land use is a planetary boundary, so that would be something to investigate. Biodiversity. Now, I don't know if this is an area that had the western chorus frog, which is an endangered species around the Montreal area that's often threatened by suburban development, but it wouldn't surprise me. But you know, this is just a very quick look at some of the issues that I thought jumped out from this example. I'm going to include in my PowerPoint, which we'll make available on the website, on the EL&G website, another example that came to me, which is the Kinzua Dam, which is near where I grew up, south of Buffalo, New York. And it was a dam that flooded a good portion, a third of the land of the Seneca Nation, their reservation, which under a treaty in 1794, the United States agreed would never claim nor disturb nor any disturb the indigenous people's use of, and they breached that treaty, and that breach was upheld by the federal court system. So this is another example that raises a different but very interesting set of issues that I won't go into right now. They're listed out again in the PowerPoint, which we'll make available to you. I want to close our portion of the website by just sharing with you an idea that depending on how these case studies move forward, there's all kinds of ways we could publicize the work. Now, my dream version of this is that a number of coordinated case studies could be started by different teams in different places. So within the leadership for the Ecozoic project, we're in the process of brainstorming and trying to develop some one or two projects that we could apply this framework to. I'll be going down next week to Brazil. I'll be there for a couple of weeks and be meeting with some researchers and students there to try and see if we can set the stage for a researching team down there to do a study. And I hope that there are others around the world who might want to do this. If we do these on more or less the same time frame, the idea would be to gather our results together to do some kind of comparative analysis, and then we could have a book or some other publication where we're introducing this idea more broadly, describing the various case studies, doing a comparative analysis, and then seeing what we've learned for going forward with this kind of work, or with the development of ecological law and policy generally. So this leaves us with about 20 minutes, and I thought it was very important with this topic to open up to all of you to share ideas, to share questions. So I'm going to do that now, and I'm going to check the chat, but if you want to, I think there's a way that you can raise your hand, or really just start speaking. Unmute yourself and speaking if you have a question. Robert, why don't you unmute yourself and ask your question?
I'd just like to make a comment about the topics of the research. I was quite interested in what you mentioned about that famous shopping mall and other comments that you made. As you know, in my practice for years, I was very much involved in real estate and shopping center development and downtown development. And I've been very interested in many of the urban conflicts and problems that we have just now that seem to be getting worse all the time. There was a very interesting analysis in the New York Times last weekend in an article called Build, 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 about a problem, an urban problem in the San Francisco Bay Area, which is really due to the incredible increase in the cost of finding affordable housing, or the difficulty in finding affordable housing. Where housing in urban areas has become inaccessible to most people, and that this is exacerbated by the wealth discrepancies that I've been so fascinated about, so that people no longer have access to proper living conditions because they just can't afford it. And the implications of that are developed in this article because there's a conflict between two groups in this little town just on the other side of the bay, sort of just a little further than Berkeley, between those who have been there and have built huge houses, and they just don't want to allow a large piece of land to be used for urban development and habitable housing. And there's this conflict that's been going on for quite a while. But what that underlies is the whole problem of urbanization. And you described the famous district just in the periphery of Montreal, which is exactly that. The commercial contractors are there and developing and using this land, which was, by the way, yes, you were right, very good land, and driving people further and further away from the center, making it necessary that people commute, use cars, consume gasoline, et cetera, with all the problems of just having access to getting to their jobs in the city. And from that, there's a whole series of problems that arise of pollution, contamination of land, consumerism, et cetera, and that to me is becoming quite fascinating if we're looking at it from the point of view that you described and what Carla described, the implication of all these concepts as you bring them together in urban development, in the rules with respect to property, with respect to the environment, et cetera, you have a fantastic case problem or case study problem or a situation, which is fascinating. Just a side effect, in that same New York Times article or paper, there was another article analyzing why shopping centers are going down the drain. They're not doing well in the United States at all. Not because of, partly because of online shopping, but that's not the main cause. The main cause is that the big shoppers are the middle class people. And the middle class people no longer have the means. They're not making enough money. They can't spend as much. The wealthy people buy expensive things and save a lot. The poor people don't have any money to buy anything anyway. So it's the people in the middle that are losing their purchasing power, that no longer can go to the malls. And a lot of the malls are falling apart in the US, are empty, have to be redesigned because of this, the poverty which is setting into that former middle class. So that whole urban question in the context of what we're talking about, I find absolutely fascinating. And there's so much work that could be done there. There's so much research there. It's a very rich and complex area. Anyway, those are the thoughts from a former real estate lawyer.
Well, you certainly have a terrific perspective to have on that. And yeah, I think you illustrate why these case studies can really, hopefully, I mean, the idea is to take this huge jumble of issues and contextualize them to make them hopefully a bit more manageable. Look at how that breaks down in a particular situation rather than trying to take the whole world out. So if we go forward, I'm glad you're in the discussion on what kinds of things we might want to study within our Montreal-based group. So Stephanie said she had a question. So Stephanie, you want to unmute and go ahead?
Yes. Well, thank you both of you for your presentations that were really interesting. And I thought it was great that both of you came up with this idea of a tool to apply these principles, because I think in legal academia, we lack structure in the way we apply theories a lot of times. So that's great. But yeah, my question was, so, and it's very pragmatic, but when you gave, Carla, your example about Bolivia and the rights of Mother Earth, I was wondering, I know that some of the problems there in Bolivia is that they are not enforced, those rights, for many reasons, but I think one of them is because procedural rights have not been necessarily facilitated to enforce those rights of Mother Earth. And therefore, I was wondering, so that impacts ecological justice. And I was wondering, how do you apply the three principles you came up with to things that are not in the statutes? So you have, well, in your example, you seem to apply them to things that are actually there, but how do you apply them to things that are not there?
Very interesting question. I haven't really thought of that before, but I suppose what I would do is, I mean, just as you select the norms that you want to look at, you can then, like if you're looking at a statute and say, for example, you're interested in procedural mechanisms to effectively enforce certain rights. So you would look at the statute and say, well, these are the rights that I'm interested in, and there's no there's no procedural mechanism. So that would be like a non-norm, I guess. It would be a norm. You could come up, I suppose, with the ideal norm and just analyze it as something that's not there. And so you would then say, well, from the perspective of each principle of the lens, this right that is here has these, you know, fits with ecocentrism and this and that way and so on. This mechanism that doesn't exist fits perfectly, and perhaps, you know, whatever existing mechanism, if there is at least something, you could also analyze and compare it. Just off the top of my head, I suppose that's how I would first go at it. Geoff?
Yeah, Stephanie, thank you so much for that question. I guess, yeah, I think this maybe we can highlight with this sort of how the methodology, once you deconstruct and analyze, hopefully that kind of issue would come out, and then in the reconstruction you can build in things that aren't there in the present system. So within the Kinzua Dam example, for example, that was a project built by the Army Corps of Engineers in the early 60s, before the United States adopted its major law requiring environmental impact assessment, the National Environmental Policy Act. So there was something that was absent. And if you go back and do that as sort of a historical study, you'd say, well, you know, what would have happened if we would have done NEPA? Now, some of these things may be more relevant to a transitional situation, which are probably more connected to reality, a little easier to describe concretely. And that's also, I think, highlights why we want to not just try to describe the fully built dream here, but try to give benchmarks, transitional benchmarks on the way where we want to go, where we have some toeholds. So that would be an example. Didn't have NEPA, then we had it. That made the situation better, but maybe not ideal on how we want to go. Terrific question. Are there other questions or comments?
I just want to say thank you because I have to go. I have a meeting soon, but thanks a lot for your presentations and your great answers.
Thanks so much, Stephanie. Katie, maybe I'll just ask you if you have anything you want to say about the webinar series, or I know you have a lot of thoughts on these issues, so please.
No. This has been an amazing first session, so thank you so much, Carla, and thank you so much, Geoff, and I really look forward to the full year. So please, everyone, check out the calendar because there are some amazing topics coming up. And then, like I said, all updates will be there. And then I'm trying to think if there's really anything else. And then for new topics, or if anything interests you, just to email Geoff or myself, because we're always thinking of new directions. And I really like that you're turning these case studies into a concrete project, you know, open for input. So we're always here for everyone. So please just keep the communication lines open. And I think this was a great start. Oh, and Christiane was on the call, and she has a few students on the call as well. And she just wanted to say that she had to jump off, but she's here for everything as well as the work continues.
Thank you so much, Katie. I don't see any, Carla? Yeah, go off. You have to unmute yourself, Carla.
No, yes, there you go. I'm just seeing a question in the chat from hold on, from Gabriela, and so she's asking whether the principles can be used to interpret statutes, for interpretation of statutes. And I mean, I think that my only answer to that at this point is to go back to Klaus Bosselman again, and his argument regarding the principle of sustainability, which of course informs all of these principles, is that the principle of sustainability actually should be recognized as a principle of law, and as such, it would be a principle like equity that would have to be used in the interpretation of any law. And so, you know, this is a stretch, I suppose, but it would be great if these principles were at some point taken seriously at the court level, or at the whatever, at an actual place in the legal system where the statutes are being interpreted, rather than just by researchers or activists. But it's a really interesting question. Anyway, thank you. I hope that I kind of answered. Thank you for that.
Yeah, thanks for recognizing that, and Gabriela, I appreciate that as well. I guess what I would say on that is, certainly one part of the analysis and even reconstruction, I think, could be a discussion of how existing laws and statutes could be interpreted or implemented in a better way without adopting new rules. So I think a big example of this is with the rights of nature, where I think a big question that's looming for a lot of people, including myself, who is quite favorable to them, is, are they going to be eroded as the courts address them? So one thing in these case studies is saying, okay, yes, this recognition in a constitution or a statute of rights of nature is good, but in order for it to be consistent with the deep principles of ecological law, it must be interpreted and applied in this way and not in other ways. In other words, it can't be trumped by certain other parts of the Constitution. It has to take precedence over them. And I think Carla's example in Bolivia showed how that's a live problem where these kinds of things exist. So certainly I would consider proposals on better ways to apply and interpret existing law could definitely be part of the exercise. All right, well, listen, I think we're about the end of the time. We've stayed within our hour and a half. I think that's a first for me anyway, but it's been terrific to get this series going again this year. Thanks so much for participating. Again, we'll both be putting make our PowerPoints available. They'll be put on the EL&G website, and we'll let folks know when they're available there. And again, Carla and I welcome inquiries from any of you that wish to be in touch with us to follow up. Thank you so much, and see you at the next webinar.